Hello, and welcome to Ipsa Dixit, a podcast on legal scholarship. I'm your host, Brian L. Fry, Spears Gilbert Associate Professor of Law at the University of Kentucky College of Law. My guest is Andrew Jensen Kerr, Lecturer of Legal English and Assistant Director for the Language Center at Georgetown University Law Center. We will discuss his article, The Perfect Opinion, which will be published in the Washington University Jurisprudence Review. So welcome to the show, Andrew.
Thanks, Brian.
Okay, so I'm so glad that we connected and that I can have you on the show. I came across your paper like a month and a half ago, maybe more, on my SSRN feed, and it's like I had to open it. It had like the greatest title and the funniest abstract, and I was not disappointed when I read it. It's a really awesome piece, so congratulations.
Thank you. Cheers.
So I wonder if you could start by kind of talking about your project in relation to the prior literature, because as you recognize in the piece, right, there is sort of a body of scholarship on sort of ranking judicial opinions. I mean, we lawyers love ranking things. So what have other scholars done, and sort of how is your approach different from what they did in the past?
Sure. Yeah, no, I appreciate the prompt, Brian. So I think that this was sort of a project that I didn't go into super intentionally. And I was kind of just originally thinking that this could sort of be a kind of a descriptive survey. And my guiding question at first was what is your favorite judge's favorite opinion? So kind of, this, I think, perennial idea of, kind of surveying who do we think is the best at doing something and what is their favorite thing in this sort of genre. And as I started kind of thinking more about this project, I was thinking about how can I, situate this within some adjacent conversations to give it more of a scholarly appeal. And so I think that historically, this has been sort of an aesthetic or qualitative question where, typically you think about the canon, the big names in our jurisprudential history. And so there's the famous study by Judge Posner about 20 or 30 years ago where he was looking specifically at Cardozo. But in his survey of what made Cardozo great, he kind of compared him to other icons from Supreme Court history. And then I think in maybe more recent decades, this has become maybe not taboo, but sort of at least a little bit less rigorous. And so there's a line of scholarship from kind of empirical political science, people like Professor Spriggs at WashU, who have been thinking about how can we use citation counts as evidence of greatness or even possibly perfection. And so this is sort of the starting point that I kind of used to sort of situate this. And then I guess one other sort of important paper to mention, Brian, is Professors Dworkin and Levinson, maybe 20 years ago, published a piece for the Harvard Law Review where they kind of commented on the canon and constitutional law. And so kind of a curious sort of insight there is that, I think for other disciplines, whether literature or other parts of the humanities, I think that kind of implicit in what people teach is a question of what do you like the most? I think that when you're thinking about great films or great literature, sort of, implied in your course design is, do we like these novels? Do we like these poems? Do we like these films? And in law, I don't know if we ask ourselves this question very often because an opinion could be important just because its doctrine is consequential or for historical reasons. And so, again, this is sort of not a common strain of legal thinking, but there's been a few sort of adjacent conversations about how we might think about likability, what makes something good, and maybe what makes something perfect, even if this is sort of an aesthetic way of thinking about law, which isn't necessarily a vogue way to think about it anymore.
Yeah, well, so one of the things I really liked was, like, as you say, there's sort of like this historical body of work kind of thinking about judicial opinions almost from an aesthetic standpoint, and then another body of scholarship sort of, as you say, thinking about them from a much more sort of quantitative, sort of analytic standpoint. And in a way, your paper kind of combines the two, as it were. I mean, it's like almost like an analytic look at the aesthetic qualities of a judicial opinion. So I wonder if you could talk a little bit about sort of the framework or the methodology that you use for kind of investigating and categorizing the kind of qualities that we might look to in identifying what makes an opinion great, but also like what makes us like or dislike it.
Sure. Yeah. So, it's sort of a kind of an amateur empirical survey in some ways, and a lot of it is just Googling and doing Westlaw and other data catalog searches for words like favorite and like, and just kind of seeing sort of what pops up. And so I tried to, it was sort of a combination of my own judgment of what makes another jurist important, whether a judge or a scholar, and then trying to sort of triangulate word choices that they might use to kind of suggest what they like the most. And so there is this kind of, a personalized approach to research that I use to try to just kind of find what these opinions are. And then once I located them, I tried to collate them into different categories. And so in the paper, I kind of begin with two categories that are maybe interesting, but don't really inform my theorizing as much. And so the first two categories I kind of categorize are just sort of the straightforward conventional majority opinion that uses case law, that looks like any other judicial opinion, but happens to be a favorite judge's favorite opinion. My other category are opinions that are fun. And so some listeners might be familiar that West Publishing put out a book called Blackie the Talking Cat and Other Favorite Judicial Opinions, and I think in the 1990s. And it's just sort of these fun opinions because the subject matter is so peculiar or strange, and there's something almost kind of silly or droll about it. And then my other two categories that I collated were opinions that are dissenting opinions or concurrences, and those often contain very few citations. And then I conclude with my ideal of perfection, kind of echoing Ronald Dworkin, the Herculean opinions. And so these are the majority opinions that are both some important people's favorite opinions, but also those that cite to nothing or almost nothing that are majority opinions. And so that's sort of the rough categories that I use.
So you use judges as your sort of data filter. Why judges? I mean, it seems to make sense, but sort of what was your thinking in looking to judges as opposed to, say, like academics, right? Because our opinions are super important. And what did you find? I mean, when you started looking at what judges had to say about opinions, what they liked or disliked, or what they seemed to find kind of most appealing, or what they themselves sort of strived for in an opinion, what did you find?
Yeah, no, I mean, there was sort of a happy coincidence here between how I began my research and the results here. So I chose judges just because they're sort of a discrete category, and this kind of echoing back this kind of, what's your favorite rapper's favorite rapper, your favorite painter's favorite painter, your favorite judge's favorite opinion. So just sort of the kind of the resonance there. And I guess part of this kind of is moving forward with some of the insight, but the thing that we kind of assume is that judges, especially common law judges in the US, are sort of conditioned and kind of wired to think in terms of precedent, and to cite to prior case law, because they've, just been kind of wired into thinking about stare decisis and the value of stability and consistency. And just because there's sort of a good manners thing where you'd want to cite to your colleague and just kind of continue that sort of the line of thinking there. And one of the peculiar kind of insights of this project was that a lot of these common law judges list or identify their favorites as being non-authoritative opinions, whether dissents or concurrences, or these majority opinions that cite to no cases or few cases. And so, it's just sort of, what does this mean for our common law culture if judges who we think are, typified and distinguished by their love of precedent actually might not love precedent that much, or at least in this special universe of cases where they select these. And so that was sort of a useful coincidence for my research. As far as scholars, I do try to kind of supplement a little bit of the theorizing here by citing to a few stylists and scholars. I think, part of it was that I wanted to kind of rely on content and information that was already out there. And so I had some suggestions about whether I should kind of survey colleagues and just other scholars, but I was a little bit anxious to kind of open that Pandora's box and just sort of, put people on notice that I might be using them as fodder for my project. And so I kind of just like the sort of organic element of seeing what judges had already identified previously.
So reading the paper and kind of looking at the data that you gathered, I was struck by the way in which, some of the opinions that judges mentioned were ones that were kind of iconic and that I was, immediately familiar with. I could almost like recite lines from some of the opinions, like, Holmes's dissent in Lochner, for example. I mean, it just really does stick with you. But a lot of the other ones were like kind of self-citations from judges, or in some cases, opinions that were sort of like, maybe I heard of that one, but I can't place it off the top of my head. I mean, were there things that sort of surprised you or struck you as you were gathering the data, or sort of patterns you started to see about what opinions judges were choosing, why they were choosing them, and sort of what appealed maybe to different judges or different kinds of judges?
Yeah, no, there was certainly some curious findings, and there are sort of the iconic cases that you see, and even those though were interesting, just to the extent that you mentioned the Holmes case I write about. Both Abrams that I mentioned and Lochner, he's writing in dissent, so to the extent that might be intriguing that he's in dissent there, but I think one thing that you might ask yourself is how organic or spontaneous are these judges being? Like, so for example, there are maybe sort of the unexpected citations from judges based on their politics, whether it's more of a conservative justice citing to a case that represents a kind of progressive ideal, and then there's also, as you mentioned, just sort of these cases that are just sort of unknown or not really remembered. And so, for example, Chief Justice John Roberts, I think that from my memory, I didn't write about it because it didn't pop up on my third and fourth category that I theorized most about. But I think that he chose an admiralty case that I had never heard of, and I was I think a Souter case from the early '90s that he selected, and then certainly the most charming and sort of surreal case that I write about is the Levesque versus Anchor motor freight case, self-selected by Judge Bruce Selya from the First Circuit. And so that's really just a hidden gem. And if I have any goal for this paper beyond my own theoretical contribution, I hope it's just that readers become familiar with this Selya case, because really it's a gem that I think has been until now sort of overlooked.
Yeah. Okay. So I totally want you to describe that case and explain why it's interesting to listeners, especially because it intersects so beautifully with a paper and interview I did a few weeks ago with Alexa Chu and Kevin Bernardo on citation stickiness, where they did kind of an empirical counting study of when judges were and weren't taking citations from the briefs that the lawyers filed, and they stipulated that in their study they intentionally excluded cases that didn't cite any opinions whatsoever, one of which was a Posner case, and the Selya case, or the Selya opinion that you mentioned, falls into the same category. So, I mean, and I love it too. It's just amazing. And I wonder if you could describe it just briefly.
Sure, yeah, I'd love to. So this is actually early in his tenure as a First Circuit judge. I think it's from the early to mid '80s, and it's, as you described, it's sort of a run of the mill negligence case where I think that they're at an auto dealership, or I think it's a dealership in Rhode Island, and they have, you know, one of those double-decker semi-tractor trailers that you see on the interstate, where there's new cars lined up on both racks of the truck. And I think that they have it, they're unloading the cars, and so they put the ramp behind it. And for whatever reason, this is the unfortunate time that the car comes off too quickly, or comes off when it's not supposed to. And I think that one of the other coworkers suffers not a terrible injury, but he's obviously injured by the car. And it goes to appeal to Judge Selya. And you know, we can never really know for sure what the decision was at the lower court, and exactly what is informing Judge Selya's overall decision here, that the trial court decision stands, that there is in fact no negligence on the part of the dealership or the coworker. But it raises sort of questions of both negligence, sort of the role of the jury, and the role of a judge in overseeing a jury in a negligence case like this one. So that's sort of the prompt for his opinion.
Yeah, well, one of the things I loved about it as well is, like, not only is the opinion citationless, but it also has this incredibly Baroque language in it as well.
Well, yeah, no, it's obvious that Judge Selya knows what he's doing, and so you know, this kind of goes to my paper a little bit. That is, as judges, you know, we can assume that when they decide not to cite something, that this is intentional and that it's not an accident. I don't think any judge writes their opinion and then afterwards she thinks, oh, I forgot to include a case here, or that was an accident, that didn't happen. And I think in the same way here, Judge Selya is certainly aware of the Baroque word choices that he uses. And so it's sort of unclear, you know, to what extent is this a joke? Is this sort of an inside joke with himself, where he's sort of, you know, is he not expecting anyone to read this ever? And is he just sort of, you know, kind of placing this as a time bomb within Westlaw, so people like me or the two of us can read this 30 years later and joke about it? Or is this like is he trying to bring attention to himself and, you know, speak to his other colleagues and say, look what you're making me do? You know, you're making me waste, you know, important judicial resources to think about this case when I could be doing something else. And so it's obvious he's using funny language, and it's unclear whether he's trying to bring attention to himself or whether he just thinks no one's ever going to read this, and so I might as well be funny, or some combination of the two.
Yeah. So one thing that struck me reading the paper was, like, what does the sort of citationless, non-precedential quality of the sort of ideal opinion from a judge's perspective say to us about sort of the role of citations and of precedent, and sort of the role of the judge more broadly, you know, from a kind of legal realist perspective? I mean, like, what does it tell us about what judges think they're doing and maybe what they're actually doing?
Yeah, you know, this is a deep question. And, you know, so part of the paper, you know, thinks a little bit about, like, what's the meaning of citation? You know, this is sort of a legal realist sort of, you know, thought line, and it's picked up today by people like Professor Schauer. You know, what's the point of citation? Is there something there, or is this just decoration? Is this, you know, is this just kind of an aesthetic? And then the paired question is, well, what does it mean if you don't cite to anything? You know, and so if we have these sort of legal realist kind of skeptical ideas about the value of citation, you know, what's happening when there is none? And, you know, legal writing if there's anything that distinguishes it, besides, style points for precision or clarity, there's this idea that legal writing is tied to authority, that it's, that your selection of precedent should be wise and good, and that it should kind of, frame your own argument. And so when there is no authority, you kind of wonder, is this legal reasoning at all? Is this law? Kind of what's happening here? And so the Levesque opinion, it's intriguing because it hasn't been cited very much, but it's been cited by a few people other than Judge Selya himself. And so, there is some kind of, it has, over time, first principles about black letter negligence doctrine. But,
yeah. Well, that's one of the things I loved about it so much, though, is he explains that there are no citations in the opinion because they would be superfluous, because the principles at stake are so well established that there's no reason to cite to precedent, because any precedent, I guess, in a sense, would almost cloud the waters in a way.
Yeah, so there's this kind of feeling that, he's doing something aesthetic, that there's a kind of a beauty here. And it's a little bit ironic, but if you were to include a case citation, it would sort of subvert what he's trying to achieve here, which is to write this, kind of intriguing citationless opinion that is, informed by the law, but it's not, it's not botched by it, or, the citations don't distract from the reading experience.
So in your paper, you also kind of use Ronald Dworkin's metaphor of Judge Hercules, as it were, as the sort of model judge who presumably would write the model opinions. So to the best of your ability, sort of thinking through Dworkin, as it were, what kind of opinion would Dworkin's Judge Hercules produce?
Yeah. So the as I was writing this, and I was trying to sort of, find a kind of a normative way to frame my kind of descriptive conclusions here, I was thinking, this sort of echoes the work of Dworkin and his idea that, we can locate the principles in the law, that this is not to cite back to Judge Posner, that we're not just coming up with a law and econ theory outside of the law that tells us the best policy outcome, but we're sort of searching for the principles within it. And even though we might not be citing to specific case law for these principles, that they're sort of there. They kind of permeate, and it's kind of informing what we're doing, or at least what Judge Hercules should do. And so, Dworkin, I think that he cited to the Riggs versus Palmer case, the famous 19th century case about the boy that kills his uncle to collect the estate, or his great uncle, something kind of like that. And there's a few cases that are cited. So, it's I think that there's just sort of a kind of a conundrum here, Brian, that I don't really form my own clear conclusion on. Is this a good thing to cite to absolutely nothing? Is the ideal judge going to, write a purely first principle opinion that doesn't cite to any case law, or should it be, should there still be some case citations to sort of anchor it and let the reader know that legal reasoning is different somehow from pure philosophizing? But it's a deep question, and it's one that I try to broach in the paper, but I don't know if I have my own really firm idea of what perfection means here.
Well, so reading the paper, I kind of got the impression there are almost like two related but distinct categories of perfect opinions. And one was like the Holmes dissent in Lochner or in Abrams, I couldn't help but think of some of Justice Douglas's dissents in sort of the same category as well, right? And incidentally, as an aside, the Holmes dissent was written at the last minute, because the Harlan dissent was actually originally the majority opinion, and an unknown justice changed his vote at the last minute, making Peckham the majority vote.
Oh,
And so,
wow.
yeah, and so the opinions were actually switched, and so Holmes kind of dashed off his dissenting opinion at the last minute, which you know, you kind of feel it like that, right?
Sure.
Like it's something he wrote in like half an hour sitting in his chair or something. But you know, the other kind of perfect opinion is like the Justice Jackson Youngstown concurrence, right? And it seems like they have certain structural similarities, but very different kind of aesthetic qualities. And I wonder if you could just briefly kind of compare those two and talk about how you think they relate to each other in relation to how judges think about the kind of perfectness or the aesthetic qualities of a judicial opinion.
So yeah, with Justice Jackson in Youngstown Sheet, you know, there's certainly a rigor to it. There's an organization. He puts forward the three-part test where he speaks to the sort of ebbs and peaks of executive power. And he even refers back to moments or events in American history almost as precedent to draw wisdom from. And so, you know, it's studied and erudite in that way, even though it doesn't necessarily have in-text citations. Whereas Lochner, the Lochner dissent from Justice Holmes, as you say, and I agree, it's sort of this kind of spontaneous thinking about, you know, how do we think about, you know, the role of government to decide, you know, should we have bakeries that are open a certain amount of time, you know, that kind of speaks to this idea of, you know, what does the Fifth Amendment mean when we think about liberty? And so, you know, both these opinions share this kind of citationless form, even though one of them has its own kind of internal logic, whereas the other one reads almost as a personal letter to a friend or a diary entry.
Yeah, no, I think that's, that's really interesting. So, I mean, in terms of thinking about what those judicial preferences tell us about the concept of perfection in an opinion, I wonder if, like, in closing, you could reflect a little bit, or kind of, what do you think about the relationship between kind of perfection and quality in opinions? I mean, is a perfect opinion a good opinion? And are judges like kind of in a position where they have to choose to sacrifice one for the other? Or are those qualities in some way complementary, or at least potentially complementary?
So I think on the, you know, the question of sort of pure style, about just being an elegant, effortless stylish writer, you know, those are, I would hope, sort of ideals that all judges might kind of chase for. As far as this sort of notion of the Herculean opinion being citationless, or you know, being able to distill these principles that kind of percolate in our case law, this is a different question, and I think it's a tough one to answer. And so, you know, in the paper, I mentioned how there's sort of this kind of polarity where, you know, I assume that each year clerks, you know, when they begin their tenure with their judge, you know, they learn that it's good to draft an opinion where it begins by summarizing the facts of the case and how they prompt a question presented, and that you should move through your argument by citation to reasoned authority to justify the moves that you make. And this can be a good or a great opinion to do this. And then we have these perfect opinions, which seem to, as in the Holmes-Lochner dissent, kind of do away with all that, you know. And one question we might ask is, you know, first, what happens if you're not necessarily Justice Holmes, or if you're a young Judge Holmes before he's reached his prime? You know, what does it look like when you're kind of not there yet? Or, you know, what does it look like if you're trying for perfection but you just don't succeed? And so that's sort of a curious kind of question to ask, and we can ask if judges do seek perfection and fail. And then kind of another jurisprudential question we might kind of think about is just sort of the culture of authority and the culture of what kind of sources that we might cite to. And so again, this is something that Professor Schauer thinks a little bit about, and other legal philosophers. I think that a few decades ago, it was pretty much a shared intuition that good legal authority was, prior case law from your jurisdiction or from other celebrated courts or judges, and maybe from great scholars. Today, the question of what's a source of authority might not be so obvious. We're kind of in a time of fissure. And so, if it's unclear whether social science or foreign authority from a foreign jurisdiction, if we're not sure what counts as authority anymore, that by citing to what we think, as first principles, by putting forward a citationless opinion, I sort of speculate on whether there might be some problems here, because there used to be a pretty clear understanding of what authority was, and if today we don't know what good authority is, when we're not citing to anything, maybe there is some concern.
Awesome. Well, thanks so much, Andrew. The paper's fantastic. Congratulations. And it was really a pleasure talking to you about it.
Thank you, Brian. I really appreciate it.
The most wanted music.
Every day I think of love, thank the angels up above. They sent you into my world, baby, let me be your girl. Oh, lying in my silken sheets, I think of ways that we might meet. I'd be so good by your side, baby, let me be your bride. 'Cause I've been going so wrong, and I'm thinking maybe, baby, you're the one to make me right. Oh, baby, can't you see? You're my fantasy.
Joey was a traveling man, long and lean with a face like a baby, and she worked the night shift in the bright lights down on Washington. As she filled the ketchup jars, she looked to him like the rising sun, shining down on his dark star, shining for the